Díomh go léir, go dtí an scoilí Sutherland ar an ógóid sin. Good evening, everybody. You're very welcome virtually to the UCD Sutherland School of Law on this absolutely glorious evening. I'm particularly impressed that you would join us for this great occasion. It's been a tough year for everybody, I think both in legal practice, in the policy world and in law schools. So it's really particularly sweet and particularly nice to have something to gather together to celebrate. I just want to congratulate our editor this evening, Mark Coen, for his leadership and creativity and imagination around this project, and to the 16 contributors, I think, for the book. Couple of thoughts, if I may. I think first of all, we want to acknowledge the support of the Society of Legal Scholars for this event. The book emerges from the seminar series, which is a very eminent series and long-standing. And I'm also struck, just looking at the book, by the nature of Irish scholarship, academic scholarship. If you look at the profiles, and this is quite superficial, but nonetheless, I thought it was worth commenting on. We have 10 women contributors, so they're in the majority, which is unusual in itself. We have 6 overseas contributors, plus the then Advocate General, who would have been in Luxembourg at that time, but of course has happily returned recently to the Supreme Court here in Ireland. And we have 3 representatives from the policy and practice world as well. And finally, but definitely not least, we also have a PhD who has co-authored with Clive Walker on the project. And it's very good to see an early career researcher coming through, because it's one of the missions of the law school to create the next generation of scholars who will take our ideas and bring their critical analysis to bear on future laws, or indeed on the 160th anniversary of the Offences Against the State Act. I also see the book in a long trajectory of criminal law heritage in UCD Law School. Swift MacNeill was the first professor of constitutional law and public and private wrongs. He was a multifaceted man. In fact, he spent most of his time writing about constitutional law. He held a seat at Westminster, but he also taught criminal law. And finally, I noticed that Mark, in his introduction to the book, provides a salutary warning of the risks of stretching the concept of emergency, as the duration of this legislation would seem to suggest. As we know, thinking about our current pandemic and the enormous powers currently being wielded by through the executive, that the government are accountable not only for how they respond to emergency, which is the major preoccupation at the moment, but also how they end emergencies, and end it not just practically, but also legally. And I think it's very much the role of the academic to call out where powers have been accrued and not ended when those emergencies have ended. So in that sense, this book is a very timely project that allows us to reflect on questions that are particularly pertinent at the moment. And finally, I would very much like, I'm really honoured actually to introduce Ms. Justice Úna Ní Raifeartaigh today. And Judge Ní Raifeartaigh is a Court of Appeal judge who was formerly in the High Court. She spent close to a quarter of a century at practice, primarily in the criminal courts. She regularly acted for the prosecution in the Special Criminal Court and was consultant editor on the textbook, The Special Criminal Court by Alice Harrison. She started her career on the Law Reform Commission as a researcher and was the Reid Professor of Criminal Law in Trinity College, Dublin. She has had a long-standing interest in encouraging discussions of issues related to the criminal justice system in a manner which combines both practical and academic perspectives. Judge Ní Raifeartaigh.
Thank you very much. I'd better check first. Thank you very much. I'd better check first that you can all hear me. Okay, good. I'm getting the nod. So I'm going to take a leaf, gratefully take a leaf out of Professor Maher or Imelda's book and say my couple of focal by way of welcome. So first of all, fáilte, which means, for any of the non-Irish here, means welcome. Díomh go léir, hello to everybody, and gur maithagah asach an chora lortliv. So thank you very much for the invitation to host this and introduce the illustrious speakers that we have. And it was also a great excuse to read the book, and to be fair, I think it's one of those books I'm going to have to keep going back to over and over, because it really is a treasure trove of information, insight and perspective. As Professor Maher just mentioned there, my coming at this is primarily from the point of view of a practitioner. I did a lot of prosecution, and I did quite an amount of prosecution in the Special Criminal Court. I noticed in Ivana Bacik's chapter, she talked about Green Street and the physicality and the physical impressions that one has in Green Street. And I certainly remember going up there for the first time as a junior and thereafter, and for many years after, and how the atmosphere of it was so different from the other courtrooms, in part because of the actual courtroom, but for also lots of other substantial reasons. And then when the Special Criminal Court moved, I think that I was in Green Street on the last day that it sat as a Special Criminal Court, and then we moved down to the CCJ, at which point, if memory is serving me well, I was involved in the retrial of the Omagh bomb trial, as it was known, the Colin Murphy trial. So I think that the last day it was for mention in the Green Street courthouse, and then it went up to the CCJ, and I remember it because, again, if memory serves me properly, there was snow on the ground, and it was January of whatever that year was, probably around 2010. I also occasionally did some cases for the Attorney General involving constitutional issues, such as, for example, the belief evidence case. Now, in fact, that arose out of conviction, but it was the belief evidence case in DPP versus Kelly. And also, I remember at least one other, which was the confiscation of assets in the context of special criminal court conviction in the case of Gilligan. So I remember that. And then I was consultant editor with Alice Harrison on the textbook, which was very interesting, and lots of law, lots of history, and very interestingly, and all credit to Alice, and it's something about which I might like to say something in a minute, she was able to get her hands on a lot of judgments of the Special Criminal Court, which had hitherto not been published. So that's something I want to mention a little later on. But it's fair to say that my perspective would have been very much from a practitioner's point of view and heavily domestic. So this book was really interesting for me to look at, and I'm really looking forward to the speeches where the talks we're going to have from our two professors who I'll introduce to you properly in just a moment, because they really have an international perspective that I certainly would not have myself, and it's very refreshing to hear it and to locate the Irish system within a much broader pan-world perspective. The book itself, for those of you who probably, you know, a lot of you, because this isn't a normal format of a book launch, you haven't got it in your hands, and I will be urging all of you hopefully to purchase it at the end and give you some details in relation to that. But it arose out of in part out of a conference in September 2019 to mark the 80th birthday, if that's the word, of the Offences Against the State Act. And it's been edited, there are 16 chapters, if I'm right, and it was edited by Dr. Mark Coen of UCD. And as Imelda has said, there are a lot of different contributions, and she's given you a small bit of the sense of the profile of the contributors. It also is connected or located within a series of books, which are called the Heart Studies in Security and Justice series. And the editor is one of our speakers. We're very honoured to have her, Leora Lazarus. So that's a really interesting looking series, of which I actually wasn't aware. But just to give you an idea of some of the titles in the series, you have things like Surveillance, Privacy and Transatlantic Relations. You have Permanent States of Emergency and the Rule of Law. You have Security and Human Rights. And you have Coercive Human Rights, Positive Duties to Mobilise the Criminal Law under the ECHR. So that's just some of the titles. And it will give you a sense of why this fits very nicely under that umbrella of publications. What I think is so interesting about this book is the number of perspectives that are brought to bear on the whole issue of the Offence Against the State Act and the Special Criminal Court, which is closely linked with it, obviously. I think that we are, I won't say celebrating, because that may not be the appropriate word at all, but perhaps marking the 80th, or we're marking at the time of the conference, the 80th birthday of the Offences Against the State Act. So if one thinks in terms of birthdays, one thinks of gifts, and I think I mentioned a treasure chest earlier on. If you open up this treasure chest, you will find a lot of parcels and a lot of interesting, mysterious packages that when you open them up, you find all kinds of interesting things in them. So for example, you'll find, if you open up some of the earlier chapters, you'll find some packages and parcels concerning the historical context to the Offences Against the State Act. And while it is dealt with in considerable detail in some of those early chapters, for example, by Niamh Howland, who talks about the 18th and the 19th century emergency powers, and Thomas More, who does, Stuart Hogan says, a very learned exposition of the period between independence and the 1937 Constitution, if memory serves me. You will find that historical references abound in the book. So it's a theme. The historical context is something that keeps coming up again and again. You also have contemporary practice being very carefully described. What's interesting again is, I think, for example, the use of data and statistics in some of the chapters, which I found refreshing. It's rare enough to find in Ireland. And also you find a good awareness of how sometimes there are things that are on the statute books or powers that are permitted that are actually in fact not being used anymore, how things have changed on the ground, even though the legal theory might be slightly different. So you'll see some very close analysis of contemporary practice, for example, picking randomly, and I hope I don't offend anyone by leaving them out, but picking randomly Liz Heffernan's chapter on belief evidence, and I think it's with Owen O'Connor, and then also Alice Harrison talking about disclosure and things like that. You also have looking to the future as well as the past and the present, and I was very struck, for example, by the chapter about freedom of expression and how that meshes with the Offences Against the State Acts, and I think that's where the Act really starts to show its age. And I thought that was extremely interesting because obviously we live in a very different world, an online world, which was not envisaged by any means at that time when the Act was crafted. Another perspective is the international perspective. And this is very, very well developed. And you'll find, I suppose, twofold perspectives on this. First of all, a description, various descriptions of what other countries do in relation to problems of, I suppose, what are generically called terrorist crime. And as you might expect, there are references to Guantanamo Bay and references to America and the UK. But what's very interesting is the net is cast much more broadly. And it literally goes around Europe and around the world. And you have examples from all over, which are extremely interesting. I think what you also have as well is repeated reference and light being shone on the international perspective in the sense of things like the European Convention on Human Rights and how it has dealt with Irish cases coming to it. Obviously, we'd be very familiar with the Lawless case, Healy McGuinness, Quinn, those type of cases, and more recently the belief evidence cases like Kelly and Donoghue. But also the critiques by the UNHCR. And interestingly, I suppose more recently contributions from the EU, and you have, I think, the framework decision in that respect. So the fact that you have this twofold description of locating the Irish system within a broader international context really adds great depth to the analysis. And also, it's not a static international climate, and it's interesting to recall that the international climate itself is changing. And that's a point, I think, that's made quite colourfully by Gerard Hogan in his foreword when he contrasts his experiences of American lawyers talking about the Irish system and then talking about their own decades later and his indignation. So read it for yourselves, it's very interesting. But obviously the world has changed, and so the nuances of that, it's not a monolith to say that there's an international perspective. That's a very complex story too. And there's also, of course, a different perspective, which is locating or orienting the Offences Against the State Act within the Irish criminal justice system, what one might call ordinary crime. And so, of course, you'll see themes, for example, Claire Hamilton talks about the contagion effect. And lots of the different authors reference the fact that it's been extended out to gangland crime in terms of things like membership type offences and belief evidence and things like that. Detention for investigation, which was the prototype, as it were, was the Offences Against the State Act. Inferences from silence, which came in somewhat later. They've moved into mainstream criminal law. So there's the compare and contrast, and then the flow from one to the other, and that's all discussed and highlighted. There's discussion of the relation between the evidential and the procedural provisions to more general or theoretical principles like the presumption of innocence, and well-embedded procedures such as the cross-examination tool, if you like, in a trial. And then there's some practical discussions, for example, of how the situation concerning the whole of the apparatus, as it were, or the machinery of the Offences Against the State Acts and the Special Criminal Court might be improved, even if they are to stay. So, for example, you have Ivana Bacik talking about the strengthening of parliamentary oversight. And you have Alice Harrison talking about disclosure, and she explores a number of different practical methods. So it's a really rich and layered analysis of the Special Criminal Court. When I was thinking about this this event, the formal launch of the book, I was asking myself the question: what makes a court special? I mean, we call it the Special Criminal Court. And various things came to mind. I mean, one that occurred to me is that, and it's a very obvious point, but I think it's still worth pausing to consider it, that in the Irish criminal justice system, it's not merely a practical reality that we have this, nor even that it's a striking feature of our legal order. It's actually embedded at the highest level in our current constitutional architecture. And I think that's a simple but fascinating point in this area, because it says so much about our history, the centuries before independence, the circumstances of independence, and then the years before the introduction of the 1939 Act and the Constitution itself in 1937. But it's interesting to pause and consider that it is of a constitutional order, and what is the effect of that? I mean, apart from the legal effects that we all know about from the case law, compared to Article 2A of the Free State Constitution, what I mean is, does it in a way desensitize people to the idea that it's different, that it's extraordinary, that it's special, because it's embedded so fundamentally in the fundamental law of the state? Another thing I was asking myself was, by what standard are the various extraordinary or special features to be judged? I mean, one standard would be compared to the rest of the country's criminal justice system. Another, of course, is the one that may be coming to the fore today, and that's to do with the international dimensions. So the international consensus, if there is one, on aspects of a fair trial. And depending on which criteria you apply or which measuring stick you apply, you might come up with different answers. For example, classically, the presence or not of a jury, because a lot of countries might not consider a jury to be essential for the administration of justice, but in a common law country, it's a departure from the norm. So it depends what criterion you're applying. And you can apply that to lots of other issues, such as detention for questioning and drawing inferences from silence and various other things. So it's just possibly something to think about. It also struck me from the enormous amount of information that's in the book about different countries that, and it's a cliche, but to use the word spectrum, there's a spectrum perhaps of exceptionality. And it might be useful to think of that as involving a spectrum where a system lies on the spectrum, and you look at a number of different factors. For example, one of the ones that comes up a lot in the book is who tries the cases? Is it judges? Does the system permit of military judges? Is there security of tenure? Things like that. So who tries the cases? What procedures and evidence are used? And I say them in the same breath because they tend to be very, very closely linked. What offences, which is also closely linked with the evidence, but for example, membership offences are having prosecuted them and having contemplated them from a practical point of view, membership offences are really quite an unusual type of offence. The publicity or otherwise of trials is a dimension. And maybe a slightly more abstract one, but nonetheless very real in practical reality, the degree of executive control or the transparency of executive control over various aspects of the procedures, or even the existence of the court itself. So I'm thinking here of things like the DPP's decisions about who to send to that court, the reviewability of that, the Gardaí, when they claim informer privilege, in a sense are closing the executive door to the scrutiny by the court, and parliamentary oversight and government involvement in the process. So those might be aspects that can be looked at and then broken down into lots and lots of subheadings, but perhaps one thinks about a spectrum. And if that is so, Ireland, I think it's fair to say, has travelled along the spectrum over the last 80 years. And some people would put forward the view, and I really hope not to express, and I don't intend to express any views, any personal views here at all. But so some people would say that it has changed so much since the early days of the Special Criminal Court that it really is identical or almost identical to the ordinary criminal courts in Ireland, with the exception of the jury. And that's a proposition that needs to be, I suppose, subjected to careful scrutiny. I mean, certainly there are still aspects that many would consider still controversial. And again, I'm not saying that I think so, but I'm simply saying that these are the things that tend to be discussed among lawyers and perhaps out in the public arena. Obviously, the absence of the jury, the belief evidence, the disclosure issues that Alice Harrison talks about, the parliamentary oversight or inadequacy of it, allegedly, the transparency or reviewability of reasons for putting someone there from the DPP, the expansion to gangland crime, and so forth. And it's interesting, I think Mark Coen himself provides a really interesting insight into his chapter about what he calls an ambivalence in Ireland, at least in some circles, at least at a certain time, towards the very concept of jury trial, and I'm paraphrasing it much more crudely than he puts it, that it was seen as a colonial import. And he makes an interesting point about how many English judges talk all the time about the wonderful right to jury trial. It's much rarer to hear Irish judges talking about that previously or now. It's an interesting concept. I hadn't thought about it before, but it's interesting that if that ambivalence is there or was there, where is it now? Because people do still see the fundamental difference, I think. Perhaps it's symbolic, but the fundamental difference between the Special Criminal Court and the other courts has been no jury. So at another level, and the jury in the criminal trial is, as I say, either symbolic or real, and probably the latter point of focus for Irish criminal trials, point of focus for it being ordinary. And what's distinctive about the Special Criminal Court, among so many other things, is that's symbolic of all the other things that are different. So I'm going to hand you over now very shortly to the two speakers, but what I think is really interesting is that we're going to hear from people who have great expertise, knowledge and research in the area of international perspectives, human rights perspectives. And I think, again, just throwing it out for discussion and getting the juices, the creative juices flowing without in any way endorsing any of these thoughts. I mean, I suppose what one needs to, as a system, always consider is whether we've become desensitized to it, whether we've become complacent. On the other hand, is it a necessary evil that has to be tolerated? Is it not an evil at all? Is it a sensible, rational approach to problems posed by particular types of crime? Should the court be there at all? Should it be retained? Should the framework and the architecture of the Offences Against the State Act be retained in many fundamentals but tightened up? Are there serious principled objections to it, or is it a political football that simply erupts at particular times between particular public parties? Is there sustained and informed public discourse about it? What would help inform that? Well, I think this book is going to be very helpful, but we'll have to get everyone to read it first. And personally, as I mentioned earlier, the Special Criminal Court did not publish its judgments. And in fact, I was mentioning to one of the judges recently that I think we should put them up on the court's website, because they do write quite long, detailed judgments now. And I don't see why they shouldn't go up onto the court's website any more than, say, High Court judgments. So I think that would be interesting for people, for commentators to be able, and the public to be able to see what's actually happening in court, at least from what the judges, how the judges are describing it. So to get the perspective on all of this from the experts, let's hear from our speakers. So our first speaker is Leora, I think. So that's Professor Liora Lazarus. One thing I'm always envious about in introducing academic speakers is how much they get to travel and how many different places they've seen. So she is currently Professor of Law at the University of British Columbia, a graduate of the University of Cape Town, I think originally from South Africa, born and bred as far as I can make out. She's graduate of University of Cape Town, LSE, London School of Economics, and University of Oxford. She was head of research at the Bonavera Institute of Human Rights at the University of Oxford. Then she moved into British Columbia in August of 2020. She has done some extremely high profile and well-known work in the area of contrasting Prisoners' Rights, which was published by OUP, and also Conceptions of Liberty Deprivation, which was published in the Modern Law Review, the MLR. So really her focus is always on the security and fundamental rights relationship, which, as you can tell from the series, the titles in the series I mentioned earlier, that's very evident. She is the founding editor of that series, and it's in that series, as I say, that the Offences Against the State book is published. So I understand that Professor Lazarus is going to talk to us primarily, I think, about the human rights aspect, and I'm greatly looking forward to hearing this, as I'm sure is the entire audience. So very welcome, Fáilte, Professor Lazarus.
Thank you very much. And thanks everybody for inviting me to this collection. Can I just have a thumbs up that you can hear me? Okay, so I just want to begin by acknowledging that I'm joining you from what is known as Vancouver in Canada, which is in the unceded territory of the Coast Salish people, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. And I also want to acknowledge that as a South African who lived in England and have just moved to Canada, I have very little understanding of the colonial and contemporary context of Ireland. So I come at this discussion very much as a non-expert on the specific context of this book. And of course, in some ways, this is very much a book about Ireland. Having said all that, I thought I would begin by saying only a few words about the book series in which this book is included, the Hart Studies of Security and Justice. Now, I was asked by Richard Hart before his retirement to think about how to conceive of the ideal book series for my field of study. At the time, I wasn't quite sure how to define that, and I'm still not quite sure, but it seemed to me to be an excellent opportunity to establish a space where scholars of different disciplines could come together to write and think about the broader issues of security and its relationship to law, constitutionalism, rights, criminal law, public law, or even private law. My desire was to develop, as we say in the blurb, a series that invited theoretical, doctrinal, and empirical multidisciplinary approaches to the relationship between security and justice. Now, I knew this could work because in 2007, Ben Gould and I collected a group of such scholars to come together, which produced the first edition of Security and Human Rights. And that book contributed to a transdisciplinary language on which to hang so many complex questions in this field. I also know that scholars don't happily step outside of the discourse unless invited to do so. So it wasn't until that collection, for example, that Ian Loader actually thought about the idea of human rights and came up with the concept of the cultural lives of rights. So why am I talking about my own book when I should be talking about another? Well, what I wanted to say here is that this collection does exactly what I'd hoped the book series would achieve. It brings together a diverse range of scholars to think about the themes of security, emergency, and counterterrorism from all sorts of perspectives. But something that is very clever here is the way in which these scholars are asked to speak about one piece of legislation in one jurisdiction. Edited collections, having done a few myself, are often hugely difficult to shape. They are the intellectual equivalent to herding cats. Pruning and putting them together under broad themes so often produce unwieldy and sometimes artificial connections, which are often artfully designed in the introduction after the fact. Not this collection. The great thing about this collection is that one piece of statutory law is given center stage, and from that springs all sorts of nuanced and diverse engagements. As I said, I came to this book as a non-expert in Irish constitutionalism, Irish history, or even Irish security and justice law, but because of its clarity of design, I was immediately able to see the general themes that flow from it and inform international scholarly debate. And for this, I want to give Mark Coen a huge congratulations on holding that structure so tight and crafting such an accessible and clear introduction, allowing the centerpiece of the Offences Against the State Act to act as a foothold for rich and generalizable theoretical inquiry. And I also want to acknowledge, as the book does, the contribution that Fergal Davis made to the idea behind this book. So apart from structure and design, I want to say that the substantive gift of this book is that it gives scholars a sustained, historical and contemporary example of the way in which exceptional legislative forms can take hold over time within a legal system, and one which raises so many fascinating themes. The first theme that jumped out for me from this book is the theme of exceptional legal forms and their relation to colonialism. Now, this was a product of including a number of chapters with a historical lens on this statute. So many of the emergency powers we see today have become embedded into our contemporary frameworks of legality with very little understanding of the historic origin. I cannot tell you how often I have seen security and justice scholars refer to a notional time of normalcy before 9/11, as if this was the key turning point in legislative history when everything changed, or worse, even referring to Northern Ireland and the troubles in that time as a deviation from an uninterrupted peaceful constitutional evolution in the United Kingdom. Despite the excellent work of leading authors and Irish scholars in the United Kingdom, including people like Canadia, there is a strange lack of ability to grasp this historical origin. And clearly the genius of British Empire was in being able to bury its historical lead. Gladly, a lot of this is changing. Having just moved to Canada, I'm struck by the way in which decolonization and colonialism is moving closer to the center of the legal academy and its approach. And I'm noticing that this movement, also present in Australia and the work of Dylan Lino, for example, and New Zealand, there is now a deep, growing scholarly engagement with the colonial legal forms of empire and their enduring legacy. So I see the chapter by name Howland in this collection very much as a contribution to this important field. I thought the chapter's account of the colonial prehistory of the Offences Against the State Act and the way in which this legislation exists on a continuum of special legislative measures introduced to suspend normal criminal justice procedures in Ireland over the 18th and 19th century as a must read for any student learning about UK constitutional history, as well, of course, of Irish. It was good to see that this theme was picked up by Fionnuala Néileán in her chapter on special criminal courts as well. And she said emergency powers of special courts were not new prior to the enactment of the 1937 Constitution. Such powers were an inherent and integral part of the colonial structure in Ireland, central to the maintenance of military and political control on this island. Finally, on the question of colonization and legal form, I thought that Mark Coen's chapter on the way in which pre-independence experience of trial by jury in Ireland under British rule and since was particularly enlightening in explaining the lack of political impotence relating to the challenges to the question of trial by jury. The second theme of this book relates to the way in which exceptional legal forms, which come about in times of instability or emergency, metastasize and make permanent homes within the so-called normal legal system. Now, this theme, which is slightly separate from the colonial framing, is one that many scholars have thought about for quite some time. And I'm very proud to say that Alan Green's book, Permanent States of Emergency and the Rule of Law, in this collection is clearly the leading theoretical text in this field. And also, hello, Alan, I can see you're in the group. What I think is excellent about this collection here is the very circumscribed focus on one piece of exceptional legislation over time. And this allows authors to tease out this general debate on exceptionalism and legal permanence in crystalline ways. I have rarely seen a case example more well made in this respect, not least because the complexity with which this metastasizing works is brought out in so many different ways and so well. So in this respect, I think the chapters by Alan Green, Claire Hamilton, and Thomas More are very important contributions to the field. In Thomas More's chapter, we learn in rich detail how the history of emergency law in the Irish Free State could be presented in terms of a series of legislative acts that have had a cumulative impact in normalizing provisions that were once widely perceived as repugnant to the principles of rule of law and individual liberty. In Alan Green's chapter, we engaged with the very nuanced concept of less exceptional emergency powers and the challenge this category presents to our thinking on constitutional reform of Irish emergency powers under Article 2833 of the Irish Constitution. And in Claire Hamilton's chapter, we welcome a criminological lens on the process of what she calls contagion between special as opposed to normal criminal justice processes. And I want to round off this theme with a particular reference to the timeliness and urgency of this particular discussions. We are living in exceptional times, but are we? The pandemic has closed off so many of our tacitly enjoyed liberties and freedoms of movement. But within this shift is a complex social ability to normalize the experience. I don't know about you, but the things we took for granted in February 2020 are no longer there, but somehow life has gone on. Our lived experience of this pandemic is undoubtedly one of normalization. And if this is true for us, then how much more true is it for those socially and politically maligned? So I just want to emphasize this experience for you, as I have been acutely aware that talking about this issue about this question of temporality, permanence, and impermanence has become a very pressing social and theoretical issue. The third theme that I want to pick up is the complex role of international human rights law that is brought to the fore in this collection. And on this theme, I have a number of my own thoughts. There is a common public expectation that human rights are always in conflict with security measures. For this reason, there is much talk of exceptions or derogations or rebalancing, whatever the discourse is. And we even get lots of security populists actively discrediting human rights institutions for this reason. But this binary division between human rights and security is too simplistic. Human rights are now both claims to security as well as rights that might limit the state in the pursuit of security. And even where limitations of rights apply, we see very often that human rights conceptions are often elasticated in the face of counterposing security imperatives, even without derogation measures being applied. And this is very much the case with procedural rights under Article 6 in the European Convention on Human Rights, or with a rather soft-touch assessments of the conditions for derogation. So it is not a surprise that despite some incremental victories, as described in the collection, what we see in the chapter of Yvonne Mary Daly is a story of the impotence of international and regional human rights law over a significant period of time. We hear of the consistent ongoing concerns of the UNHCR in relation to the Special Criminal Court and the lack of any impact of these concerns, even in the case of individual application. We also hear of the European Court of Human Rights support for islands derogation from Article 5 in the famous Lawless case, and a high level of tolerance for belief evidence under Article 6 jurisprudence. Even where victories have been won in cases like Heed and McGuinness, we see the muted impact of these judgments on the presence of the legislation of the offending section 52 of OSA. Although clearly, and also referring to those practitioners who have a much deeper understanding than I do, this has had a much more significant impact on the practice of the courts. One point that Daly raises, with which I strongly agree, is the increasing relevance of EU human rights law as expressed in a line of new EU directives. And I'm inclined to say that the strongest impact may occur in the EU area of security, freedom, and justice. And I would be happy to return to this question in discussion. But the main theme here is the striking insight that despite all of these human rights avenues, provisions, individual applications, etc., as well as the incorporation of many of these rights into domestic law, the OSA exists in modified forms despite the absence of stated continuing emergency conditions. This raises a big question of the role of human rights in the legitimation of emergency law. Finally, alongside the big thematic question, the collection gives us a very strong account of the nitty-gritty questions that are relating to the challenges for the rule of law and human rights. Essential reading on this comes in the chapter from the Special Rapporteur on Terrorism and Human Rights, Len, on the Special Criminal Courts, which he describes as a conveyor belt of exceptionality, marked by a contradiction at the heart of its institution. And I thought that one passage, comment she made was particularly prescient. She described the Special Court as having a contradiction at its heart. To employ the designation court is to mark the institution out as judicial, clearly distinguishable from an administrative tribunal. The court is to be a vehicle of justice rather than for convenient disposal of the state's enemies. Yet to be special implies a departure, a derogation. So it is no surprise then that the Special Court takes up 4 further chapters from Nicola McGarity, Liz Hefferman and Anne O'Connor, Alice Harrison and Liz Campbell, all dealing in different ways in which the court deviates from accepted standards of criminal justice process. I found the chapter from Heffernan and Anne O'Connor particularly helpful on the rights claims against belief evidence, and of course, the comparative approach from Nicola McGarity was illuminating for readers outside of Ireland. Finally, 2 further chapters raised important rights concerns on the prescription of unlawful organizations by Clive Walker and Jamie McLaughlin, and the chapter on freedom of expression by Laura Donoghue. Donohue's chapter was particularly helpful on the challenges of new forms of media and the inadequacies of this legislation. Clive Walker and Damien Plochman showed too how the powers of prescription remain strong and track these powers back into the deep into the colonial period. So I should probably end my overview here and leave the deeper constitutional questions to my more expert colleague, Colm and Canadia. But I want to conclude by saying how excited I am that such a rich, expert, and highly coherent collection has been included in this book series. I recommend this read for all who are interested in emergency powers, security and human rights, and constitutionalism more generally. I also recommend it to those tracking the antecedents of coercive measures within the colonial time. This collection gives you a deep resource in exposing the colonial structures of legality that live so intact with us in contemporary times, and all of its authors are to be congratulated and contributing to it. Thank you very much.
Thank you very much, Professor Lazarus. That's fascinating. Wonderful gift, as well as your knowledge, to express very profound things and broad things in very succinct manner. You've given a lot of food for thought there. I was very interested when you talked about the ECHR, and I was struck by, I think in one of the chapters, I can't remember which one, where there was almost a disappointment perhaps on the part of the author that there didn't seem to be any listening to the reports of the UNHCR and some of the European court judgments. And what I think is interesting in that regard, I don't know if anyone's read a recent publication by Gráinne de Búrca on reframing human rights. I think it's called something to do with the turbulent times. And it's very interesting because what she takes is human rights in well, I think she calls it the experimental method, but in any event, she's looking at the dialogue between a domestic system and a European system, and how it may have an influence. She takes particular case studies. It might be interesting to do a case study on the Special Criminal Court. And she takes case studies, and some of them are Irish actually, but not all of them are. And she does Pakistan, she does Argentina, and she works through what was happening at a domestic level and how what was being said at the international level to that country was influencing. So it can have a softer influence as well as a hard influence. And it's a very interesting theory, I think. And so I have no doubt that practice on the ground in Ireland, as well as legislation on inferences, has been shaped indirectly as well as directly from what's been happening at the international level and the European level in particular. Okay, so I would now like to introduce our next speaker, Professor Colin Canadia, who I think is going to concentrate more on the comparative constitutional context. And he is a professor of constitutional and human rights law at University College London. And he originally was a graduate of UCC, University of Edinburgh then, and he obviously did the barristers at law degree at the King's Inns. And his field is very much constitutional human rights and anti-discrimination law. And he's also, interestingly, a specialist legal advisor to the Joint Committee on Human Rights and the Women and Equalities Committee of the UK Parliament. And he also acts as an advisor to various international organisations, including the UN and the European Commission. And he was a member of the European Committee on the Social Rights of the Council of Europe, and was serving as vice president for a certain period of that, 4 years, I think. And he's been member of the Academic Advisory Board of Blackstone Chambers in London, so he's got a very broad range of experience as well. So it'll be fascinating to hear his take on these issues through the prism of this particular book. Welcome and fáilte, Colin.
Great, Gurmil Mahagov. Thank you. Hello all. I'm calling in from a very rainy and eerily quiet London. There's apparently a football game on or something like that. Soccer, as I persist in calling it, actually, which marks me out as a deviant minority here in Britain. I read this book with immense pleasure. And of course, it's entirely standard to turn up at book launches and to say you read the book with immense pleasure, even if you gritted your teeth and waded through it in 6 months. This wasn't the case with this book. It was an absolutely tremendous collection. A collection with great tribute has to be paid to Mark Coen as editor. It's uniquely, I think, cohesive as a collection. And it contains a great mix of different perspectives. There's a sort of historical set of perspectives, chapters from Niamh Howland, Thomas More, Mark himself, and others, tracing the development, the historical development of special courts and special courts mechanisms in Ireland, going back to the British period and carrying on to the present. There's the multifaceted sort of criminal dimension, the different aspects of criminal law impacted on by the offences against the state regime. with fabulous chapters from Liz Campbell and many other contributors focusing on that. There's a fascinating chapter on the Offence Against the State Act impact on free speech and social media in particular by Leora O'Donoghue, which certainly for me opened up new ground, opened up new ways of thinking about some of these issues. And a really, really excellent set of concluding chapters by James McLaughlin and Clive Walker, Claire Hamilton and Alan Green, looking at some of the overarching thematic issues arising in respect to the Offences Against the State Act and the associated special criminal courts. It's an incredibly rich collection. Capped off, I have to say, by Ivana Bacic's absolutely superb chapter, which combines her role as both a litigator before the court and also a parliamentarian, which is a perspective you don't often see. And her chapter is, I think, worth the price of admission alone. There's so much to praise about this book. I'm going to cut my my course of praise short, but just to point out a couple of things that stand out before making some couple of thematic points and then shutting up. One particular aspect about the book, which I found absolutely fascinating, was the contrast between the foreword to the book written by Gerard Hogan and the introduction written by Mark. Because the introduction, coming after the foreword, is an excellent overview of the Offence Against the State Act and the Special Criminal Court, a summary of all the chapters. And because it's summarized in the chapters, Mark's focus in the introduction is to identifying common themes, and he zeroes in on a lot of the concerns that exist about the Offence Against the State Act regime and the Special Criminal Court. So it's an introduction thick with concern about aspects of the legislation and the functioning of the court. That's in fascinating contrast to the almost cheerful tone of the foreword by Gerard Hogan, who is, as always, a pleasure to read, who cheerfully affirms that he was correct in the 1970s in UCD to argue when he was a student in favor of the Special Criminal Court and the OASA regime, and that history has in effect proved the correctness of having the OASA and the Special Criminal Court, albeit recognizing the need for potential reforms, as indeed his minority contribution to the Hedgerman report recognized 20 years ago. So the contrast between the foreword by Gerard Hogan and the introduction by Mark is absolutely fascinating. There's sort of the tone of those two segments of the book tells you so much about some of the debates that are unfolding about the legislation and the Special Criminal Court. The chapters are also, of course, dotted with absolutely fascinating nuggets. I'm going to just pull out one, Thomas More's chapter on page 27, which I never knew, I have to say, which apparently in the height of the Civil War, or in its immediate aftermath, there was discussion in the provisional government in Dublin about effectively renting the island of St. Helena in the Atlantic from the UK government to hold the amount of Republican detainees in the aftermath of the Civil War, which is a little nugget of history I had no idea about, which again, I keep on saying it's worth the price of admission alone, that little fact. I have three thematic points and then I'll shut up. And I'm coming at this not as an expert in criminal law, not as an expert in Irish practice and procedure, but as a sort of comparative constitutionalist with a human rights equality focus. First theme, continuity. It's absolutely fascinating to see the same debates about the validity of the legislation in its different forms running through from the 19th century on. You know, in Niamh Howland's really superb chapter on page 19, you see judges in late 19th century Dublin being very resistant to the imposition of a special non-jury courts, refusing to serve on some non-jury courts. You see discussion about, you see debates in Westminster in 1889, worrying about the erosion of the normal criminal procedures by emergency procedures in Ireland. And it's fascinating as the chapters go by to see this continuity keeping on coming up over and over, similar debates through time. You also have Mark Coen's absolutely fabulous chapter on jury ambivalence, this idea that jury trial is often occupied a slightly ambivalent role in the Irish legal and political consciousness. He has a really fascinating quote from Conor Maguire, then Attorney General former and subsequently Chief Justice of Ireland, where he describes the institution of jury trial as an Anglo-Saxon innovation and something that Ireland might be better off ditching, because of course the Breton courts had no jury trial. It was a sort of an Anglo-Saxon import. It wasn't native to Irish legal consciousness. That's a really interesting nugget. Again, an example of the sort of in-depth scholarship that's informing so much of this chapter, so much of this book. So you see really fascinating continuities running through back to the period of imperial rule, continuing all the way forward to contemporary debates. A second theme is turbulence. There's a tendency in the comparative constitutional scholarship, an increasing tendency, to portray Ireland as a sort of a zone of constitutional stability, of a good constitutional order that rests on firm and solid foundations, linked to the overall success story of the development of the Irish state since independence. It's interesting reading these chapters, again, the long historical perspective, to be reminded of how turbulent the 2030s and 40s were in particular, but also the early 1970s. And to also see how often there is a perception in certain quarters of currents of organized armed resistance to the state or to its police authorities, creating zones of law and disorder, so to speak, non-law and disorder, and these perceptions persist to this day. So it's interesting to see this counter narrative of turbulence, and also to see some very frank discussion among ministers and civil servants and judges and lawyers about the need for special measures, emergency powers, so to speak, to use the Schmidt phrasing, to deal with this turbulence. That's a sort of an interesting counter narrative to some of the perhaps complacency about Ireland's constitutional history. Thirdly, you have the really interesting question of Ireland, the Irish constitutional order's relationship with the wider international human rights framework in which it's embedded. Now, Leora has already discussed this to some extent, as has Justice Úna Ní Raifeartaigh. Yvonne Daly's point, page 191, that the Kavanagh versus Ireland decision of the UN Human Rights Committee not been cited by the High and Supreme Courts in subsequent litigation, the fact that the Heaney judgment of the ECHR has never been formally fully implemented, even though jurisprudence has shifted over time. These are interesting points, and it's interesting to see so many of the chapters highlighting the importance of the international human rights framework, in particular the ECHR, as a very, very important comparator point, but also to see sometimes how there's often a tension and uncertainty in terms of how that is received within the system. Though, as Justice Úna Ní Raifeartaigh has just said, it is perhaps quite significant that some of the major adjustments in the case law relating to the functioning Special Criminal Court in particular followed quite quickly on the heels of concern being expressed in Strasbourg. I have to say, it's interesting how the issue of jury trial plays out in this regard, because of course, membership of the ECHR, Ireland is rather exceptional than the ECHR, because we are a legal system that makes extensive use of jury trials. Of course, most continental European systems don't make extensive use of jury trials, and certainly not for security-orientated offences. I once had a French doctorate student who was very amused by the agonies that the British legal system was going through when it came to deporting terrorist suspects, or failing to deport terrorist suspects because of concerns about the ECHR. According to my French doctorate student, there's a special court in Charles de Gaulle Airport which cheerfully dispatches detainees back to Algeria, justifying it all by reference Article 3 ECHR on the grounds of the special and unique close relationship between the French security services and the Algerian secret police. basically we know they've told us we won't torture them, so that's fine. We're in regular contact with them. And that's interesting. I'm not sure to what extent that is still the case in France. Things have changed in France in this respect under ECHR influence over the last 20 years or so. But it is interesting to think about some of these tensions being a common law system, placing a high formal premium on jury trial, subject to the reservations in Mark Coen's system, but embedded within an international human rights system, the key point from our purposes, the ECHR, being a mechanism that, for obvious reasons, doesn't perhaps prioritize jury trial as much as other common law systems would. But there are some general points just to throw into the conversation. I'd just like to conclude by again mentioning the extraordinary quality of this book. I'm not just saying that. It's a remarkable book. I learned so much from it, and all the chapters are readable. And the mixture of theory and practice of different perspectives makes for an incredibly rich collection, which has been remarkably well edited and pulled together. So I can say about this with an entirely straight face, which you can't always say about academic books. It's a really, really, really superb read. So I will then shut up and thank you to Mark for the invitation to speak with us.
Well, thank you very much, Professor Canadia. I mean, I think what I was struck by so many things reading the book, but one of them was, and I agree very much with what you've just said, about the committed and serious legal scholarship that's going on in Ireland in the area of criminal justice, coming in at it from so many different angles, criminological, historical, the details, drilling down into everything, you know, from the tiniest of historical details to the macro international perspective. It's really a very exciting time for criminal justice scholarship. And I not only would like to actually hear a lot more about all of this from all these people in the book, but also from the two speakers who have whetted my appetite even more. So it's all extremely stimulating. Before I introduce Dr. Cohn, the man of the moment, I do want to say as well that I was also very struck, Colin or Professor Canadia, but about the contrast, the tone of the forward. And I wasn't thinking so much of the introduction, but the rest of the book actually, because the rest of the book was very much focused on concerns and potential reforms and slightly pessimistic and critical tone, whereas the forward by Gerard Hogan was of a completely different tone, and I was very struck with that. I'm wondering would any of the commentators take up his position, but in fact none of them did. So that was very interesting. Now, the man of the moment, as I say, the man responsible for all this treasure box of wonderful scholarship in collating it and creating an organic whole is no doubt known to all of you, Dr. Mark Coen. And in turn, I'll introduce him as a graduate of Trinity College, Dublin University of Oxford. He's currently in UCD Sutherland School of Law, and he's been there for 6 years, and previously had lectured in a number of institutions, including Durham University, DIT, TCD, and DCU, lots of acronyms there. Former president of the Irish Association of Law Teachers. And as I know myself from dealing with him, one of his great interests is the issue of trial by jury. Both from a contemporary, he's doing very cutting edge research on that, and historical perspective, which we would have seen in the chapter in this book, with a particular interesting insight on ambivalence, which I also was very struck by, I think it was referenced by Professor Canadia there. And he's widely published in the area of criminal justice in various periodicals, the Criminal Law Review, Legal Studies, International Journal of Evidence and Proof, Human Rights Law Review, American Journal of Legal History, and the Law and History Review. So there's an enviable track record of publication there. I honestly don't know how you all get all the time to write so much in so many journals. Do you ever sleep, I wonder? But in any event, in March 2020, Chief Justice Clark, current Chief Justice, launched Judges and Juries in Ireland, an empirical study, which is the report that Mark was leading with Dr. Niamh Howlin, and in which I participated, in fact, where judges, I think, anonymously published, gave their views as to interactions with juries. So wonderful, as I say, cutting edge research, and more to come, I believe, and certainly hope. So I give you Dr. Mark Coen.
Thank you very much, Judge Úna Ní Raifeartaigh, for that lovely introduction, and thank you to everyone who's attended tonight, as was said at the beginning, you're competing with fine weather in Ireland. It might be rainy elsewhere, but it's very fine in Dublin this evening. And I also know the novelty of online events has sort of dimmed by this stage in our pandemic experience. So thank you very much for attending. It's interesting that Judge Ní Raifeartaigh spoke there a moment ago about the richness and the dynamism of the research environment in Ireland at the moment. And I think we're all very lucky to, as academic scholars, to participate in that environment. But I was looking earlier at Mary Robinson's work from 1974 on the Special Criminal Court. And in her introduction, she says, anyone engaged in research in Ireland expects to find it a lonely task. And I thought there was I felt a real contrast almost 50 years later after the very rich and energetic journey I've been on in editing this book with 15 wonderful travel companions who were the authors of the pieces. And who gave of their time so enthusiastically and so readily. And I'm still speaking to all of them, glad to report as well. But quite a contrast there with the research environment described by Mary Robinson in the 1970s. So I have a few thank yous to say, which I'll say at the end, and I just also want to make a few quick remarks, but I am conscious of the time and will endeavour to be brief. In my introduction to the collection, I suppose I focus on the fact that over its history, the Offences Against the State Act appears to nearly always have been A, controversial, and B, topical. Some issues remain constant. I suppose the derogation from jury trial being the main one. Others come and go. As has been referred to, I think Judge Ní Raifeartaigh said this as well. There are a number of provisions in the Act that are still on the statute book but are no longer used. So thankfully, we no longer have military officers sitting on the Special Criminal Court. We're not living through a period of internment, but controversies come and go at different times. I suppose in more recent years, some of those have been, the extension of some provisions of the Act to organised crime, the ongoing issues relating to Garda opinion evidence, and very currently at the moment, the future trial of Lisa Smith before the Special Criminal Court for membership of Islamic State. I suppose another thing that keeps the Act topical is the parliamentary renewals that have been referred to as well that have to take place in relation to certain provisions under the Offences Against the State Amendment Act 1998 and the Criminal Justice Amendment Act of 2009. So only last week, in fact, we saw the Offences Against the State Act hitting the headlines for a number of reasons. One was that Sinn Féin TDs walked out of the Dáil, the lower house of Parliament here, before a vote was taken, which is actually, I think for perhaps the last number of years they have abstained rather than voting again. So it is a somewhat a softening of their position, but a lot was made of it by their political opponents that they weren't prepared to support this legislation that is necessary to protect the state from those who would usurp or destroy it. Another interesting thing that happened in the course of those parliamentary discussions last week was that we were introduced for the first time by the independent TD Michael McNamara to the idea of a Monaghan Caliphate. I don't think anyone had ever heard of that before or the possibility of it, but he was criticising the decision to try Lisa Smith before the Special Criminal Court and raised this spectre of a Monaghan Caliphate. Perhaps the most welcome contribution to the parliamentary proceedings last week, however, was made in the Senate by Senator Bacik, who referred to a recently published book on the Offences Against the State Act and commended it to the House. So I regarded that as a particularly welcome contribution to the debate. So I suppose I have been reflecting in advance of the launch on the enduring topicality of the legislation, which also struck me, as I say, when I was writing the introduction. I find it interesting that the contrast was noted and pointed out at the launch by a number of contributors as well. And it's certainly there, and you will see it in the book, the contrast between Mr. Justice Hogan's foreword, the introduction, and the remainder of the book. I suppose another reason why the Act is particularly topical at the moment is the creation by the government of the Independent Review Group to examine the legislation. Indeed, a contributor to the book, Dr. Alan Green, is a member of that review group, which is to be very much welcomed. And I'll even give a free shout out to the review group and say that they are seeking public consultations on the legislation, and that window of consultation is, I believe, open until the 9th of July. They have a very good website. I think it's oasareview.ie, where you can find out information about the review and make submissions. I've yet to make my own submission, but I intend to do so. While one would welcome the establishment of such a review group, I would incline to be a bit cynical as well. There was an excellent and very thorough review conducted by the Hederman Committee, which reported, I think, in 2002. It made many thoughtful recommendations about how the system of the Offences Against the State Act legislation could be improved, and it was roundly ignored. So I suppose it will be interesting maybe to come back for the 100th anniversary of the Offences Against the State Act and see, well, what did this review group, independent review group, recommend, and what actually happened at a political level in relation to its recommendations? Because I think we have a lamentable culture in Ireland of commissioning reports that make recommendations, often very thoughtful recommendations, and then just roundly ignoring them. And I'll mention a bee in my bonnet, which is the Law Reform Commission's very good 2013 report on jury service, which appears to be meeting the same fate as the Hederman Commission report, consigned to dusty shelves with no sign of implementation. So I would, I'm probably continuing my critical and concerned, I think it was characterized as, tone of my introduction, but I think there is a history in Irish officialdom of commissioning these reports and then doing very little to follow them up. So I hope I will be proved wrong in respect of the independent review group. I wish it well in its work, but it would be interesting to see what happens in that space. Finally, if I could be so bold as to make a suggestion to the independent review group, I think it would be well worth publishing the submissions that are made by interested parties to their consultation on the legislation. This is a practice, for example, that is adopted by parliamentary committees in the United Kingdom when they seek submissions from members of the public. I think it is good practice in a consultation to be able to see, who has made particular arguments and what arguments are they making. And of course, it would give academics material as well. So, but I don't think that's the main idea. I would encourage them to do that. I think in the interest of openness and transparency, that would be, I hope that they do that. I was very taken, I'll finish my kind of substantive points here before moving on to the thank yous that I have to make. I was taken by Judge Ní Raifeartaigh's reference to the practice of the Special Criminal Court in not publishing its judgments on courts.ie. This has been another bee in my bonnet for a number of years, and I actually went rooting in emails. I had a correspondence with the registrar, or I'm not sure if the same person is still the registrar of the court, but the then registrar of the court in 2014, and wrote having written saying, I don't understand why the judgments are not of the Special Criminal Court are not routinely available. Occasionally journalists get them, and in high profile cases, and they are published by newspaper websites, for example. And the response I got, I'm not giving you the most current of news here, but the position in 2014 was, it has not been the policy to publish judgments of the Special Criminal Court online. given the nature of the business dealt with and the reasons why cases are directed to be heard in that specialized environment. So it seems to be, or at least to have been at some time, a deliberate decision not to publish the judgments of the court. But I would be very interested to see if there will be developments in that particular area, because I think if there are security concerns, that there are ways in which certain things could be anonymized in relation to the identity of judges if that was deemed necessary. I don't think it's proportionate really to deprive the public of the full the judgments, that the reasoning that the court releases. And from the few that I have seen, it engages in very detailed reasoning on factual issues as well as legal issues. So then it comes to the sort of acknowledgements part of my contribution. So a bit like an Irish wedding, a speech at a wedding, lots of thank yous, but they are very heartfelt. I'd like to acknowledge the support of the Society of Legal Scholars, who, as has been said, basically enabled me to hold a 2-day seminar in 2019 to mark the 80th anniversary and funded that event. Mr. Justice Gerard Hogan has been a great supporter of this project. He was the keynote speaker at the seminar, and he has written at the foreword, which I think you will find of interest, as has been said. I'd like to thank Professor Imelda Maher of the Sutherland School of Law for her encouragement and support. I'd also like to thank my colleagues, in particular, Niamh Howlin and Thomas Moore. Hart Publishing have done a wonderful job, and they were a joy to work with. They made my job very easy, and there have been a lot of compliments on the look and feel of the book, which is testament, I think, to their professionalism. I'd like to thank in particular at Hart, Kate Wetter, Linda Staniford, Emma Platt, and Rosie Mearns in particular. I was, as I say, very lucky with the contributors to the book. They were great companions on the journey. I've heard horror stories of people in academia who have edited books and are war-weary veterans at the end because of what the contributors have put them through. Maybe the stories are on the other side in this book. Maybe by pushing for cohesiveness and clarity, I've driven my contributors demented, but I hope not. It was a joy working with them, and I thank them very much for their involvement in the project. I'm very grateful to my colleague Una Kelly, who's put a huge amount of effort into supporting this project at all its stages. Una gave me amazing support during the seminar in terms of organizing and running that, and has done so much to make this launch a reality. I sort of naively assumed there wouldn't really be much to an online launch, but I think there's as much work, if not more, to this type of launch as to an in-person one. So thank you, Una, so much for your support and professionalism and commitment. Ms. Justice Úna Ní Raifeartaigh is always a great supporter of academic endeavour, and I'm really honoured that she chaired the launch today, and she gives so generously of her time and is so approachable. She said she doesn't know where academics get the time, but I actually don't know where she gets the time to be pleasant and approachable to academics with mad ideas while engaged in her other work and commitments. The brilliant insights of Leora Lazarus and Colm Canadia really added to this launch for me, and I'm so humbled and grateful that they took the time to read the book and participate. Thank you both. I'd like to thank my friends who are in attendance. Some of them have no interest in the Offences Against the State Act, but are just here in the capacity of friend. So you know who you are. If you've had to sit through this with no interest in the subject matter, I appreciate you doing that. Thank you. And lastly, a special thank you to my partner Colin for his love and support. And thank you all for attending this event. I hope the book is of interest and that you enjoy it. Thank you.
Well, before we sign off, there's a very practical matter which I must draw to your attention, which is about purchasing the book. The book is available on discount, in particular at UCD Book Shop until the 14th of July So that's at €73.80 instead of €82. And you can also have it, you can make orders by phone also, and it can be posted within Ireland. So just to encourage everybody to avail of that opportunity. And I think then it's time to wrap it up. Thank you.